introduce Arupji, and then hopefully if Professor Rajat joins in that time, great. But if not, we'll introduce him after Arupji's address.
Sure, sir. Please go ahead.
Sure. Hey everyone, thank you all for joining today. This is an L2 Pro webinar on synergizing the role of IPR and industrial designs in the modern world. I am Dr. Hemang Shah. I work for Qualcomm India, and I'm also the co-chairman of ASSOCHAM's IPR Council. And we are excited to bring today's webinar to discuss this very interesting topic on industrial designs. Now, we started working, on these topics simply because of our work with startups since 2016. So since 2016, Qualcomm has been incubating and mentoring startups in India. Till date, we have worked firsthand with 125 plus startups in the country. And we have done a lot of IP workshops with them, done a lot of mentorship sessions, and we understood what their pain points were. We took these observations to DPIIT, and that led to the introduction of a completely free course for startups, which is called L2 Pro or L2 Pro India. And I'll just share, some of my slides with you on this course. So this is a collaboration with DPIIT and specifically CPAN in the DPIIT and NLU Delhi, which is National Law University Delhi. You can see the picture of the core team which has been working on this course. Now, what L2 Pro aims to do is to demystify what intellectual property is, and specifically how folks in the startup industry, how folks in the research or academic verticals can better absorb IPR and can become practitioners. So the idea is to help you understand how to protect your innovations with patents, how to use copyrights to protect your software, develop trademarks. You have to use IP as a core part of your business strategy, because ultimately a lot of research work is being done, and we need to obtain value from that, and how we can bring those innovations quickly to market. The course is split across 3 different modules. We call them basic, intermediate, and advanced. In my opinion, everyone should be familiar with the basic module because that covers the fundamental IP rights which are of relevance to most startups and researchers. Then if you are further interested, you can dig deep into the intermediate level, which goes into the behind the scenes of what happens with IP and its related considerations. And in the advanced section, we look at how we can look at funding and access to venture capital using IP rights, how standards and standard setting organizations work, and with IP rights, there are disputes which happen. So how can you approach any dispute if that occurs? Now, at the end of each level, there is a case study based examination. So again, the goal is not to give you factual information which you can get from book. The goal is to make you a practitioner. So that case study will give you a real life situation, so that you get in the mode of thinking that if I was in such a situation, what will I do? Now, we made this course to be of relevance to startups and SMEs and researchers. So it's very interactive. Here you can see how the course is presented. I'm showing some screenshots from our mobile app. We also have resources where you can, it may be hard to read, but here, for example, at the IP India website, you can find the list of patent, design, and mark facilitators. So where can you find those? So look up.
मेरे पास वो आएगा भी नहीं. I'm not supposed to get all that.
Srividya ji,
हाँ.
thank you. With every lesson also, there are 2-minute introduction and summary videos, because we understand time is of the essence for everyone. If you spend just 2 minutes in this video, you'll learn about 70% of the lesson. That's my estimation. And for the rest of the details, you can go through each lesson according to your convenience. We have pop-up quizzes which come up, and again, that keeps it a bit more fun and interactive. Now, the best part is that at the end of every level, there is a certification, there's a test, and the people who pass that exam successfully, they get a certificate which is provided by DPIIT, by NLU Delhi, and by Qualcomm. This is automatically provided into your account. The entire course is completely free to use. You can access it at l2proindia.com, and we'll also be sharing links to where you can download the app for your favorite app store. And the course is light and free. So far, we have more than 6,100 learners who have taken advantage of this course, and we look forward to seeing you there. So with that, I will stop the sharing, and we can dive into the speaker module of this course. Kirti, if you can enable me to stop sharing, please. Okay, thank you. I would like to introduce our first speaker of the day, Mr. Arup Garu. He is an assistant controller of patents and designs at the India Patent Office, Kolkata. He works in the design section. Arup ji has completed his MSc in chemistry from IIT Kharagpur and has a research experience of 5 years at IICT Hyderabad, after which he joined the patent office as an examiner of patents and designs. He has examined a substantial number of patent examinations and has also assisted the controller to take the decisions. In 2018, Arupji got promoted as the Assistant Controller of Patents and Designs. Until date, he has been working in the Design Office, Kolkata. He has also visited Japan for patent examination management training program at the Japanese Patent Office in 2018. And Arupji participates in various IPR promotion programs, awareness, as well as training programs. Arupji, very happy to have you on board with us. Thank you for sharing, your insights and agreeing to spend time with us today. I look forward.
Thank you for this introduction. So good afternoon, everybody. Should I start my session?
Yes, please.
Okay.
I can see your slide.
Is it visible to everybody, sir?
Yes.
Okay. So very good afternoon to everybody. Myself, Arup Garu, working as a assistant controller of patents and design in the design wing since in 2018, and in the patent office Kolkata. So as Sir Hemant sir already given the introduction about me, so I am not wasting much more time. So and I am going to start the little bit idea about the what is the industrial design as intellectual property and what is the procedure for the registration of the industrial design in India, particularly in Indian perspective view. Okay. So first. So what is in brief, before starting the industrial design, I'm giving the brief introduction. What is intellectual property? The intellectual property is something which is created from the human brain or human mind. This is called the intellectual property. And the intellectual property protection give the protection of our human brain creation or human mind creation. So when a product has been developed by a creator, the product is associated with the several intellectual property. Like I have taken one example here, that is the television. That is just for example, I have taken the example of the television with a that is trademark Sony. So with one product, the how many intellectual property is associated. So if I consider the patent invention, that is an invention of the remote control mechanism, it can be patentable. And also the trademark means Sony is the trademark, well-known trademark. It can be protected. It is already protected on the trademark. And also copyright. If I come under the copyright, then the TV instruction manual, which is the manual is written, and generally during the selling purpose, they or the company provide this user manual to the consumer also. These under come under the copyright. And last thing is the design. What is the design? Design mainly focus the aesthetic feature of the TV, which can be protected by an industrial design. So generally the aesthetic appearance of a product or of an article is come under the industrial design. Generally, industrial design is one of the category of IPR, IP, where it focus on the aesthetic feature of the article, and it is derived solely from the visual appearance. Relevant aspects are the shape, configuration, surface pattern, the color, lines, or combination thereof. When these are applied to an article and the products of an article or the products which produces an aesthetic impression, this comes under the industrial design. Mainly the aesthetic feature of an article, it is covered under the industrial design. In brief, this is the definition of an industrial design. So what is the importance of the industrial design? One important quotes are there that Mark Deserts quoted in the Time magazine. When companies are competing at equal price and functionality, design is the only differential that matters. So if I consider on example, suppose two soaps are produced by the two companies. One is the Hindustan Unilever, another is the ITC. Am I audible to everybody, sir?
Yes, you are requesting everyone who's not speaking to please be on mute. Please continue, Arup.
Okay.
Request everyone to mute their mics, please. Thank you so much. Kirti, please mute anyone. If there's anybody else who's who's speaking. Thank you so much.
Sure, sir.
Okay. So just I am taking the one example with it, just taking one example of the soap, which is produced by the two companies. One is the Hindustan Unilever and another is the ITC. But the both price are the same and also quality wise both are same. So then what will be the differential feature of both with this product? So if one soap with having the at most attractive design, then it attracts the consumer more. So here the industrial design plays an important role to differentiate these two products. So what is the importance of the design here? That it makes a product look and attractive and appealing to the consumers, and it may be an unique selling tool or business tool. Also, it protects the appearance of your product against the copying or infringement. It also adds the value of the product, and also it gives the fair returns on the investment and build a business assets, and also it creates the fair competition among the consumers. Now I have taken few examples where the industrial design plays an important role to produce some products or industries. So actually, in brief, I can say from small pin to big aeroplane, in everywhere the industrial design plays an important role. I have taken few examples, but these are very limited examples, and the example these are not limited with this one only, with this only, with not this only. So for the few small scale industries, that is the like the day by day product using product, that is shoes, chappal, pen, textile goods. These are the very in small scale industries. There also the industrial design plays an important role. And if I consider the medium and large scale industries, like the companies who is producing the washing machine, refrigerator, television, computer, and including car and also automobile also. Everywhere the industrial design have the important role to define the value of the product. Now I have taken few examples, that is the product which are using we are using day by day basis. They are where the industrial design plays an important role. The few consumer products, that is some like scissors, office bags, and electric iron, everywhere the industrial design has an important role. These are all the consumer products which we are using in day by day basis. Now, not only the consumer products, if I come to the pharmaceutical products also, there also the some industrial design has this important role, including that is needs syringe, needle, vial for the medicines, also laboratory glasswares. Everywhere the industrial design has important role. Now I am coming to the sector where the industrial design is the only IP which define the that is define the price of the product, and also the market. It define the market value of the product. Like these are the textile and jewelry. Here industrial design is the only IP which define the market value of this product. So what is the requirement of the industrial requirement for the registration of the industrial design? So first, it will protect your new and original design, and it can be applied to any article which is the creation of the human intellect by way of the registration. And also it prevents any third party for the imitation or commercial exploitation of this innovators design without the prior consent from the provider or the registered originator. And also it obtained or reared by the commercially exploiting the design, and it gives the commercial, yes, commercial value is there when one provider can assign all licenses design to the any other third parties. And also it increases the interest to innovate the more and more attractive design in the consumer phase. Now I'm coming to the acts and the rules which is governed and which generally govern for the registration of the industrial design in India. Generally, the Design Act 2000 and Design Rules 2001 is governed for the registration of the industrial design in India. The Design Rules 2001, later on it is amended on 2008, 14 and 2021. There are total 48 sections and 48 rules are there, and 5 schedules. Schedule 1 generally defines the fees of the different prosecutions and different transactions. Schedule 2 defines the list of the forms, and Schedule 3 is the classification of the goods. Generally, we are now following the Locarno classification, and Schedule 4 is the cost allowable in the proceeding before the controller, and Schedule 5 is a certificate of registration of industrial design. Now I'm coming some important definition under the Design Act 2000. First important definition is the article. As for the Design Act 2000, article means a article of manufacture and any substance which could be artificial. Artificial means fully artificial or partly artificial, partly natural, and includes any part of an article capable of being made and sold separately. So there is the 3 important features. The article should be article of manufacture, and it should be either should be fully artificial or partly artificial, partly natural, and if any part of an article capable of being made, sold and sold separately, then it can also be considered as a article. So there is a three different example. One is the wooden toy, though it is made with the wood and it is a fully natural substance, but the toy, it is not the fully natural. It is there are the so many human intervention are there to create that is wooden toy. So it is partly artificial and partly natural. Another is the on bottle with the cap. So it is the fully artificial. And also one more thing, the cap and bottle individually can be satisfied as a definition of the article, because
ટ્રેનિંગ એટેન્ડ કરીને આવો છો કલાક પછી આવું છું યાદ છે
so
યાદ છે સર
the actually if both the cap and the bottle that satisfy the condition that they can be made and sold separately as a commodity in the market, then both the cap as well as the bottle individually can be considered as a article as per the definition of the 2A of Design Act. Now third one is the broken bottle. Though it is an article of manufacture and also it is an fully artificial, but it does not satisfy the last condition, that is it cannot be sold as a commodity in the market. Therefore this broken bottle cannot be considered as an article as per the definition of the Design Act 2000. Now I'm coming the definition of the design as per the section 2D. That it defines the what is the industrial design. There is two parts. First part is the defines what is the design, which means what parameters have come under the industrial design, and second part is the disclaimer, means which does not consider as the industrial design. So if I read the first part, that is the design means the only features of the shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional, in both forms by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. So this is the first part, which define means confine the what is the industrial design. Means it is the only feature of the shape, configuration, pattern, ornament, composition of lines, colors applied to an article, and this application process should be the industrial process. Here also it defines what is the industrial process, or means that is it may be manual, mechanical, or chemical. It may be the combined process or the separate process. And after all this thing, where it is applied to an article, the finished article, the article should be the finished article, appealed to and solely judged by the eye. So this is the definition of the first part of the definition of the industrial design. Now I'm coming to the second part. What is not the industrial means, what is the exclusion of the industrial design, but does not include any mode of principle of construction or anything which is in substance a mere mechanical device. So mere mechanical device, suppose one screwdriver, which is in a mere mechanical device, generally simple screwdriver does not consider as a industrial design, and does not include any trademark as defined in the clause 5 subsection 1 of section 2 of the Trade and Merchandise Act 1958, or any property mark as defined in the IPC in section 479 of the IPC, Indian Penal Code, or any artistic work as defined in the clause C of the section 2 of the Copyright Act 1957. So these are the disclaimer. One is that it should not be the mere mechanical device. It does not include any trademark, and it does not include any property mark, and also it does not it should not be any simple artistic work as defined in the section 2C of the Copyright Act 1957. I'll come later with some example. So these are the two part. One is the first part is in industrial design. The first part is the what is confined, the considered as industrial design. And second part is the disclaimer part, means which cannot be considered as a industrial design. Now there is a one important definition, that is set of the article. Suppose here I have taken one example of the tea pot with the tea sets. So sometimes sets also can be considered as a can be registered as industrial designs, but there are some conditions there. As per the Design Act 2000, the sets means the number of articles, the same general character, ordinarily sold together or intended to be used together, all bearing the same design, with or without modification, not sufficient to alter the character or substantially to affect the identity thereof. There is a few important parameters are there as in the definition of the set. That is, it should the same general character and ordinarily sold together and intended to be used together. And the most important thing is the all bearing the same design. So suppose if I consider this the example of the T sets, these are the with the same general character, and ordinarily they sold together and intended to be used also together, and also they are the same design features. Now the definition of the original. What is the definition of originality as per the section 2G of the Design Act? That is in relation to a design, means originating from author of the such design, and includes the cases which, though old in themselves, yet are new in their application. Just I'm taking one example. Suppose the design of suppose shape and configuration of a mango is well known, as it is naturally abundant in our nature. So these are not new, but if anybody come with some article, suppose paperweight, they have made a paperweight with the shape and configuration of the mango, then their application is the different. So it can be considered as the original as per the section 2G of the Design Act. Now I'm coming to some provision or the prohibition of the registration of the industrial design. These are come under the section 4 of the Design Act. That is, a design shall not be registered if the design is not new or original, or has been disclosed to the public in anywhere in India or in any other country by publication in tangible form, or by use, or in any other way prior to the filing date, or the where applicable the priority date of the application for registration. And third one is the a design is not significantly distinguishable from the known designs or a combination of the known designs. So first one is the if a design is not new and original, means it is already registered in India, then it cannot be considered as means this design cannot be registered. And second is the important thing, means in our India we are considering the absolute novelty of industrial design, means it should not be published in anywhere in India as well as in anywhere in the world. So in any form, it may be in the form of the publication, or in any other way, like in the form of use also, if it is known to any that is community in the world, and then the novelty of the product will be those. And also if a design is also significantly not distinguishable from the non designs, also it cannot be considered, cannot be registrable. And section 4D is the if the design contains some scandalous and obscene matter, also it cannot be registered. And section 5, if it is contained some contrary or contrary to the public order and morality, if industrial design, suppose some industrial design where there is some religious symbol is included, suppose one company is made an there is shoes where some religious symbol is included in the shoe. So it is clearly that the design against and contrary to the public order and morality. So this kind of industrial design generally in India will not be allowed. These are the few designs I have, the published design I have taken, that is which are already registered and published for the example purpose only. Now, what is the right that has been conferred to the registered proprietor when a design has been registered? So when a design is registered, the registered proprietor of the design shall, subject to the provision of the Act, have the copyright in the designs during the 10 years from the date of the registration. So what is the copyright? These are not the identical definition of the copyright in the Copyright Act. Here it is defined in the section 2C of the 1950, that is Design Act 2000, and that is copyright means the exclusive right to apply a design to any article in any class in which the design is registered. Suppose a product means, suppose I am taking one example, that is bottle. One proprietor has got registration of his water bottle in the class, that is class means here inherently included the subclass means, that is class 0901, means with this design means the proprietor can apply this design in any bottle within this class 0901. And also now I'm coming to section 11.2 of the that is Act, that is 2000, Design Act 2000, that is the initial period of 10 years can be extendable by another 5 years by filing a request made before the expiry of the initial 10-year periods. Means in India, the total term of the design is the first is the initial term is the 10 years, and it can be extendable next 5 years by filing Form 3 within the initial 10-year periods. Now, there is some provision of the Copyright Act as applied to the designs. A creator of the design shall keep in the mind the following provision of the Copyright Act, that the copyright, when a design has been registered as per the Design Act, then the copyright of the Copyright Act shall not subsist. Means when one creator create a design or create a design inherently as per the Copyright Act 1957, he or she will enjoy the copyright as per the Copyright Act 1957. But until and unless that this copyright product or this product has not been registered registered as per the Design Act. When it has been registered in the as per the Design Act as a design, then the copyright of the Copyright Act 1957 shall not subsist. Suppose any design which is capable, it's being registered under this Design Act but not registered, shall seize the copyright when this article containing the design has been reproduced more than 50 times by an industrial process by either by the owners or by the or his licensee or any third person. Means suppose a bottle which is created by a that is that is designer, but he has not taken the registration of the industrial design in the as per the Design Act. He has the copyright until unless the same design has not been reproduced more than 50 times by an industrial process by the owner of it may be the owner or maybe his licensee or by any third person. So when it crosses the 50 means that is limits 50, then it will lose the copyright of as per the Copyright Act 1957.
Arup-ji, in interest of time, can you wrap up in like 3 to 4 minutes, please? We can then invite Professor Agarwal and then turn over to you for Q&A.
Okay.
Yeah, thank you.
So how much time with me, sir? Actually,
If you can wrap up maybe 3 minutes or so, then
yes, sir.
3 to 4 minutes.
3 to 4 minutes.
Yes, sir.
Okay, I'm trying to just finish. Okay, just this is the classification system. That is the, then I have already told that is we are following the Lugano classification systems. As for the Lugano classification system, there is the 32 classes are there. One is the 31 is the main class, and one is the that is mainly graphic ornamentation, and all the classification system based on the nature and function of the article. Now these are the that is Lugano classification IPO websites. There are the all class that is 32 classes articles are further divided in the different subclasses as per the nature and use of the article. Now these are the activities generally taken place in our design office. That is the these are classified in the three categories. One is the pre-registration, post-registration, and cancellation. In pre-registration, after filing the design application, examination of the design application taken place, issuance of the IPR and ACR, after their hearings, and issuance of the design certificate and publication. In post-registration, generally renewal, restoration, alteration, or assignment, or issuance of the certified copies, and later on the final stage, any opposition procedures, that is the cancellation of the design. And now who can file the design application? Any person can file the application. Person includes the natural person. Natural person also includes the legal representative of the deceased person, and also other than natural person means large entity, and also small entity including startup. And there are the three types of applicants: natural person, small entity including the startup, and also the other than natural person in the large entity. There are the two types of filings of the design application. One is the electronic filing, and it can be filed in our electronic modules. And second one is the physical filing. It can be deposited any of these four offices, that is IPO Delhi, Mumbai, Chennai, Kolkata, and thereafter it transfer to the IPO Kolkata, where the examination, registration, and publication of the application taken place. Now these are the jurisdiction of the filing of the design application. I already discussed in the previous slide. Now what is the requirement of the applications? That is the generally for filing the design application, that is first thing is the application fees with the forms. One and two sets of representations is generally we are taking now for physical filing. And if the application is filed by any attorney, then the power of attorney is necessary. If the application is claiming any priority from the convention application, then the priority document is necessary. Assignment document is required if, and Form 24 is applicable only for the small entity or startup. Now the preparing the representation sheet, that is generally it is prepared in the A4 size papers with some photographs, and these details already mentioned in the IP India site. That is our office already uploaded that the patent office procedure, patent design office procedure in IP India site, so it can be available in our website also. There are the a few example of the novelty statement we are generally allowing in the design applications. That is the for the 2-dimensional and 3-dimensional applications, articles. That is the first one is the for the, if the design is restricted to the shape and configuration, then the generally novelty statement we are allowing the novelty deciding the shape and configuration of the article as name of the article as illustrated. Similarly, for the 2-dimensional, when the only the surface ornamentation or pattern is the important features, then the novelty statement generally we are allowing that is novelty deciding the ornamental surface pattern of the title of the article as illustrated. These are the one example of the representation sheet. Maybe the representation sheet more than 1 pages. That's not as per the requirement. These are the some example of the views which generally we are allowing, and which does not we are not allowing. That is that representation should be clear and clearly visible, and one can easily identify what is the article and design. And this is the criteria of a registration of the industrial design. I already discussed in the previous. That is, it should satisfy the some provision of the Design Act. And these are the notification after registration. The design, when the design got published, there are the few bibliographic data. With bibliographic data, it is published in our that is patent office journal. These are the some important time limits. That is the priority receptivity application should be filed within 6 months. and the reply to APR should be filed within 6 months from the date of the filing, and it can be extendable up later 3 months by filing Form 18 required fees. And also there is some that is 10 years in that is times for the draft form of the design can be extendable by 5 years by filing the form 3. Now these are the cancellation of the registration of the design. One can interested person can file the cancellation of the industrial registered design by filing Form 8 with the required fees the following grounds. That is, if the design is not new or original, no, and it is if it is previously registered in India or published in India, or it is not registrable under the Act, or it is not a design under the Section 2D of the Act. This is the one example of the certificate of the industrial yes, after the registration it is provided to the generally provided to the provider, and this is the continuous process. That is, we are modernize our design office. Latest one is we are issuing the e-certificate to email to the provider. This is the credit and source. From here I have taken this information, and these are okay. These are all about my presentation. So thank you for listening me, and yes, it is almost over. So
Thank you so much, Arupi. This was such a wonderful presentation. I took
thank you.
well,
Thank you very much.
to your address. And if you can see in the chat box, there are a number of questions. So we won't cover them right now. If you're welcome to type in the chat box and answer if you like, or we can take them after Professor Agarwal's address.
So it will be better than after the session. We can take this what is the question actually. Actually, I don't know from the chat box I can see this or not. I don't know.
There are many. What I will do is I'll also message them to you separately.
Okay. Okay. Then after the presentation, then the question may be taken. Okay.
Please, thank you. Like on everyone's behalf, I thank Arupji again for a wonderful address. And then now invite Professor Rajat Agarwal to join us. I'll introduce him. Professor Agarwal is the DPIIT IPR Chair and a professor of the Department of Management Studies and a joint faculty at the Department of Design at the Indian Institute of Technology, Roorkee. Dr. Agarwal is a recipient of the Ram Kumar Prize for Outstanding Teaching and Research at IIT Roorkee. He was the Associate Dean for Innovation and Incubation, and he has also initiated the process of establishing the Design Innovation Center, and presently is the co-PI and the coordinator of the center. Dr. Agarwal was a visiting fellow to the Copenhagen Business School in Copenhagen, Denmark. He is a Danida Fellow from the Government of Denmark and also an alumnus of APIC at the Japanese Patent Office. He was awarded the ICCR chair at Indonesia in the year 2016-17. Dr. Agarwal has more than 140 research papers in refereed journals and more than 25 research papers in refereed conference proceedings. He is widely invited to organize MDPs, address conference and training programs. He has done MDPs, which are management development programs for BHEL, Flipkart, BL, HPCL, Mittal Energy, THDC, UTDB, etc. He has authored one book published by Bloomsbury and has book chapters in 8 books. He has organized the first Pan-IIT International Management Conference in the year 2018 and various other short-term courses. Dr. Agarwal, well, it's a very stellar resume. Thank you so much for joining us here today. And we look forward to hearing your address.
Thank you, Hemangji, for this generous introduction. Thank you very much. Thank you, SHM, for giving me this opportunity. Hope I am audible to all of you.
You are, sir.
Yeah, thank you. So, in fact, I was listening the presentation of Mr. Arup, and he gave very exhaustive, you can say, detail of the process of design registration in India. What is design? What are the benefits of design registration? what cannot be registered as a design, etc. So I think that eases my job, that I need not to go into the basics of design. I will touch more upon the title of this particular program, that synergizing IPR and design. We all know that how things are changing. Many of us, those who know about Alvin Toffler, and Alvin Toffler, a very popular futurologist, in one of his book, The Third Wave, he mentions that there was a time when we used to earn money, or those people were considered powerful who used to have muscle power. So initially, the muscle power was the important source of showing your supremacy. After this muscle power, he mentions that slowly it became the money power. And from money, I can keep various bodybuilders around me, and then I can be ruling the countries, I can be ruling the economy, etc. So from muscle, we move to money power. And then he mentions that in the coming days, it will be the mind power which will be most important resource. There is a similar analogy I used to say in my classes, that from agrarian economy to manufacturing based economy to service based economy, now we are in the era of knowledge economy, where intellectual property, intellectual capital is the very important source of wealth generation. So synergizing these two things, very important. That why IPR? There are different types of IPR, which Arup was mentioning in first, second slide of his presentation, by the example of Sony, that in that particular Sony product, you have patent also, you have trademark also, you have copyright also, you have design also, and so on. So why are we talking of intellectual property right? And then probably we will come to this discussion of role of design in this. Because as I just said, in this 21st century, knowledge or mind is the main source of wealth generation. Whenever we talk of India's economic progress, we immediately start comparing ourselves with China. That how China is progressing, can we adopt the Chinese model for India's progress also? But since all of us are students and practitioners of IP, we understand that how China has done a kind of a revolution, set a new benchmark in IP area. When we talk of patents, China is filing between 12 to 15 lakh patents per year since last 6-7 years. China is granting close to 5 to 6 lakh patents per year. On the other side, if you see India, since last 3 years, we are filing between 50 to 60,000 patents per year, and we are granting between 25 to 27,000 patents per year. So you can understand the difference between the numbers of China and numbers of India. They are in lakhs, we are in thousands. Similarly, if I come to design, last year in 2022, as per the Hague Convention, which is governing the system of international design registrations, the applications of the residents of that particular country in China was somewhere 7 lakh plus. And in India's case, this number was just 17,000. And you can very well compare now that the reason why China has become a 16 trillion economy, which is now not only a challenge for India, but a challenge for America also, challenge for many European countries also, challenge for Japan also. Many of you I see must be traveling from America to Japan. And whether you go to Walmart, you go to Co-op in Europe, you go to 7-Eleven in Japan, you will find everywhere products which are made in China. China is not making simply low cost cheap products, but they are equally well placed in high tech products which are knowledge products, I can say. So dear friends, it is important to understand that if we do not protect our knowledge, it can be in the form of patent also, it can be in the form of uh, design also, it can be in the form of geographical indicators also, or any other kind of IP which Arup was discussing, we will not be able to progress in this new system. Arup comes from government system, I come from academia. We were trained in a way, publish or perish. So more and more academia, they are in habit of writing research papers and publishing research papers, because that is how we feel we will be progressing. We will get promotions from assistant to associate professor, from associate professor to professor, if we have publications, good publications, high impact journal publications. But dear friends, the rules have changed. It is no longer publish or perish. It is protect and prosper. That I feel should be the mantra of 21st century. And if we understand this mantra, why these numbers are not encouraging, the reason is very simple. We have no appreciation about intellectual property. I am at IIT Roorkee, and many a time our faculty members, researchers, we struggle, should it be protected as a patent or should it be protected as a industrial design? And many a time in our common gossip language, we have created a new term which is known as design patent. Technically speaking, in our vocabulary of intellectual property rights, there is no such term exists, design patent, but we have created a term of its own. It shows our lack of awareness for various types of IP, and to understand the role of IP in economic development. I teach these subjects in our classes, and in that discussion, many a time we say, and then our startup co-founders, they say that, sir, what is the benefit of IP? If we create IP, we do not have means that our entire information will be available in the public domain. How are we going to protect ourselves? Then we also need to see that do we have proper mechanism of ensuring proper enforcement of IP laws. So therefore, as our national IPR policy says, there is a urgent requirement of capability building at every stage of the society. Our judiciary system, courts, police, they all need to appreciate that IP is also a very important type of property. Its illegal use is equally a crime as stealing a mobile phone or stealing a car or any other type of a crime. You will find, I have experience, but you all will have similar kind of experience, that if you go that somebody is copying my design, the local courts, local police will not have any appreciation. And that is very important thing, how we need to understand the role of intellectual property, particularly the important type of intellectual properties in this case. Now coming to the particular topic, that how design is going to help in this process of synergizing the IP and modern world. Particularly, I will like to say the process of granting and registering the industrial design is much simpler as compared to patents. So therefore, the patents which require huge amount of prior art detailing to prove the novelty, because it is a functional activity, while design is more coming from the creative side of our brain. And large amount of our government of India's efforts through the national design schemes, where a lot of NIDs were developed, and in IITs also now many IITs are offering B-M programs, where students should be encouraged to register their projects under the design registration provisions. So if our schools, colleges become the training ground for our design registration, probably it will help us to create more awareness and more appreciation about proper use of IP tools for our benefits. So that is my first important point, that how can we synergize the IPR and industrial design? That is through education. That is the first important thing, where we need to understand that if we create ecosystem where we are encouraging our students, because at that time uh, the college infrastructure, college cells are available, and these college cells, etc., will help students to properly uh, orient towards the design registration. I will like to give you one experiment of IIT Roorkee, so that it can be very useful for our other listeners. They can implement the similar kind of things in their institutions, in their acquaintance also. Here we have started a system of tinkering and mentoring at our UG first year level. In UG at IIT system, when a student joins, generally for JEE preparation, they are coming with the physics, chemistry, mathematics preparation. But when they come to IIT in their UG first year, they are still studying the same physics, chemistry, mathematics. So students are generally not so excited that they are actually in an engineering environment. So therefore, now we have started a system where these students will make a project, a very simple project, and these projects are mostly design related projects, where we are asking our students that if you come with a new design of these products, so we have an intake of around 1300 students in our UG first year. So we have given some 100 products for their new designs, and they will make products in the very first semester of their UG program. So one point, they will have a hands-on experience. So that will create more excitement that yes, in engineering, it is not the same way which we were studying since class 1 to class 12. There is something different. So we feel that we will be able to make better engineers. Second point, we are feeling that with this, the application of different type of IP, some of the projects may go into the design registration, and some of the projects may go for patent registration also. So this is our first year of this experiment. First time we are doing this experiment. The results will come maybe after December, when the semester is over. Probably at that time we can share those results with SOCHM, that how our experiment has resulted in improving the appreciation at the UG student level for IPR and use of IPR for their benefit. Because yes,
Someone is confused by accident. Kavita, can you please mute yourself?
thank you. So why we came to this particular issue? We
Hello.
did Hello.
Uh, Professor, continue speaking. We will ask the others to mute. Kirti, can you please check who is speaking and mute their mics, please?
It's
Thank you
done,
so
sir.
much.
Please go ahead.
Yeah, please go ahead.
Thank you. Yeah. So what I'm saying that, sir, at IIT Roorkee, I'm giving you some practical data. We have around 130 companies which are either graduated or they are still in the process of incubation in our 2 incubators. And unfortunately, these 130 startups do not have even 130 IP on their name because of very low level of awareness. And even if they know that IP is something, they are very hesitant to realize the benefits of IP. They feel that it is more from the protectionist point of view, and it create more legal hurdles for them. So more myth are there around intellectual property, and there is therefore urgent need to bring more correct thing, factual information for the benefit of a larger population, that how IPR and different type of tools in which I feel that design is still lacking a lot, because whenever we talk of IP, it is generally considered around patent. So patent has become a synonym of intellectual property, while I particularly feel that aesthetics, because we all are living in the marketing era, and as I said, knowledge era, and at the same time it is a marketing era. And in marketing, to distinguish your product from your competitor's product, design can play a very important role. So in this era, when everything is customer centric and how customer needs a differentiated identification of your product, design can play a very important role. And therefore, if we have a tool, if we have a solution which can help us in creating that identification, so my whole point which I'm trying to emphasize, that design should be seen a tool to create differentiation in your product category. The product categories are flooded, the number of SKUs are infinite, parallelly you can say almost infinite. But still, you know that if you see a Mercedes vehicle, then you can easily identify from very far, even you don't have the trademark of Mercedes on that, that it's a Mercedes, because of the type of curves it has. Any kind of, whether it is SUV or it's a passenger car, you can easily identify. So that's the power of design, that it gives you the power of identification. So market is becoming crowded day by day because of more and more products are coming to the market, and how to create a differentiation for yourself, I feel design can be a very good tool for that. And if we understand this, probably we will be able to get more customers, or a better positioning, not customers, a better positioning for our products into this highly competitive market scenario. And that will be, I think, the real purpose of registering our designs, so that we are able to differentiate, we can be differentiated in the marketplace. So with this, I think I can stop here, and 30 minutes were allocated to me.
Thank you.
Over to you, Mr. Sah.
Yeah. Thank you, Professor Agarwal. Really, awe-inspiring address, and one, I guess, recommendation from our side. So, you might have missed the introduction where I said that we are a part of the Qualcomm incubation team, where we have incubated and mentored startups since 2016. Right now, we have worked firsthand with 125 Indian startups, and these startups have collectively filed for an overall patent portfolio which exceeds 400 patents right now. And thankfully, due to the initiatives of SIPP, the Startup IP policy, they get
Yeah.
expanded examination. So close to around half of them are already granted, and the other half are I would say, they first file in India and then they take it to international level of filing, through
Oh,
PC.
great. Very good.
So I'll be very happy to share our L2 Pro course material links with you. It's completely free for everyone to use. We
Oh,
have
fantastic.
3,100 plus learners on that, including startups, academia, and industry professionals. So I really commend IIT Roorkee. We've had a few stellar startups from there that have also applied to our programs, and we
Oh,
look forward to. But our program is more on the lines of hardware and on-device AI.
yeah, so we have a separate incubator which is part of DST scheme, iHub. So it is known as Divya Sampark iHub, which is working in the area of only the hardware, particularly IoT, artificial intelligence, and robotics. So that is the mandate of this incubator. So we have two incubators in our campus. One is very specific to hardware, IoT, etc., and the other one is sector agnostic.
Terrific, sir. We'll connect with you offline on this.
Yeah,
And
sure, we can. We'll love to have.
now we have about 20 minutes, for Q&A. So if I can also request Arupji to be available on video. I think while we wait for people to also chime in the address, so I guess one open question is, well, this question was around copyright, but let me ask that question related to designs. So nowadays we are seeing a lot of these generative AI tools, which are used mostly for text. That's what we are reading. But you can also generate innovative designs based on that. They can generate drawings. So what is your thought? Like, would those kind of designs be allowed under the Indian Designs Act? And possibly with the professor, maybe how can innovators look at these tools to improve their work?
Yeah, so I feel that as new tools are regularly coming into the market, and AI tools are very common, used for various type of creative activities also. So if these AI tools or any other tool, for example, not only AI, I will like to say, which are helping us to create new type of designs, because even in not only in the AI, but in the other kind of tools, like our design is happening through CAD softwares, and all these things are already there to add in the design process. And most of the designs which we are registering are coming out of some kind of these design softwares. So we were already protecting those designs. So if novelty is there, so the factor is the novelty is there, and if it is fulfilling the criteria of our design registration process. So even if these designs are coming and from AI tools, which is helping us in improving our design portfolio, I think there is no harm in protecting those designs.
And Arupji, is there any guideline on who the inventor can be? Let's say if it was completely from the tool, uh, but if the filer can demonstrate that they did some interaction, then maybe they are a co-filer.
Just please repeat this question. I'm a little bit loud because I'm not getting your voice properly.
So Arupji, this is with
Yes.
AI tools which are used to generate designs.
Okay.
What are the guidelines, and would those kind of design registrations be allowed, or does it require a human co-filer or a co-designer?
See, actually, first thing is that design, as per the Design Act, the definition of the design is that it's the design should be visually, means it should solely uh, judged by the eye only. Means from where it is originated and who is making this or who is the creator of the design. This is not the matter. First thing. Second, if it has the visual impression some there, and if it is a new and original design, and it is satisfying the criteria of the section 2A and 2D, otherwise, and it is not, it is a novel design, then it can be registered. But second thing is the inventor. Yes, as per the Design Act, only the applicant is the applicant or is the proprietor of the design, the registered design, and also there is no requirement to give the information of the inventor.
Got it. Thank you. This another question, Arupji, for you from Pritesh. Is it's more on the lines of the design prosecution, which is how much time will it take to reflect a change of address of service and the extension of 5 years from the renewal of design? So how much
Yes.
like these?
Actually, see, that is the processing of this change of the address for service and extension of this time limit. That is, it has been done by the from 22 and from 3 after the registration of the design. And problem is that this process has taken place till now. We are taken place in both in the physical mode as well as the online mode. So it takes a few more time, few more months maybe. And if any objection is there, then the objection letter is communicated to the concerned attorney or the concerned applicant. Or if any objection is not there, then generally it is processed within a few months.
Great, thank you. Uh, Probably a question for both of you from Santosh Joshi is his question talks about a patent attorney, but I think it is broader. So maybe with Professor Agrawal, I can ask you that when it comes to designs and patents from your institute, do you work with dedicated patent attorneys or patent agents and design agents, or does the professor do everything by themselves? Like, do you need to work with professionals for your own?
So let me respond to this, that we have one IPR cell, intellectual property rights cell, here in our campus. So if our researchers, faculty members, students, if they are coming with some novel idea, so that is the point of contact for our campus community. And then this office actually examines whether it should be filed as a patent or should be filed as a design or as a copyright, etc. Then we have a internal committee which we tell as intellectual property assessment committee. So depending upon whether the research is coming from chemical engineering or research is coming from electronics or from civil engineering or from metallurgical engineering, we make this intellectual property assessment committee case to case basis. And that committee actually examines, because it is all 100% investment, or the cost for this entire process is taken care by the institute. So for that, whether institute should go ahead or not go ahead, this committee gives a green signal. And once the green signal is given by the committee, then we may take help of our patent facilitators. So they will help to finally doing the drafting work of the application, so that it is as per the requirement of the Indian Patent Office. So just for that purpose we take the help of, otherwise the entire work is done by our office itself.
Uh, Thank you. Now, the question for you, which is from Neha, is similar to PCT. Uh, uh, yeah,
Similar to PCT.
yeah, similar to PCT, which is an international treaty for the filing of patents. What is the corresponding such treaty for the registrations of designs?
Yeah, so for this, I think Hague Convention is there, but to the best of my knowledge, the discussion is still on. Should India be part of this Hague or not? So Arup can confirm whether India has signed the treaty or not yet. But
Actually, sir, not yet. It has been done, so it is under process.
yeah,
Maybe
because as IPR chair, we
yes.
gave our comments on that about 1.5 years back to Government of India, that what are the benefits and what are the downsides of signing this treaty. And since the matter is under discussion, I will not like to give more details about that, because Government of India is considering should we sign or should we not sign this treaty.
Thank you. Now, while we wait for the questions from the participants, I will seek your thoughts on registration of designs, but this is more coming from working with hardware startups. Now, what we notice is startups that are, let's say, developing medical devices or IoT devices. At the start of their business, uh, it's a ripe opportunity for patent. because they're innovating on testing methods, they're innovating on some algorithms, devices, and all that. When they get to the production or pilot production, that's when the opportunity for design rights comes into play. But many times they miss that point. So because they're so caught up in releasing the product that they just forget designs and design rights until if they have a mentor who guides them, they end up filing for that. What would your recommendation be? How can one, be proactive in capturing what are the design rights that they should be registering?
Arup, you like to take or should I start?
So you can start. Sir.
Yeah, so this is a very interesting question, and I will give you our two important case studies on this. During COVID period at IIT Roorkee, we developed a low-cost ventilator, and we named it as Pranavayu. AIMS Rishikesh is very close to Roorkee, and we did lot of trials with the help of AIMS Rishikesh. And since, as you very rightly said, initially we thought that we should immediately protect the technology through patents. We patented it also. And later on, when we thought to commercialize this through some technology transfer to some companies, it was COVID period at that time. So companies were not coming very forward for increasing their or maybe diversifying their product lines. So it was difficult to get the customer at that time. And we were also requiring a lot of clinical trial data for because it was a healthcare device. So simply by patenting, it was not possible to get into the market unless until we have ICMR clearances also. So that took a lot of efforts, and by the time we could get those clearances, the COVID wave was almost over. So companies got less interested in commercializing. So even today, we have developed a very good package of that product also, so that it is aesthetically appealing also. But unfortunately, we were focused on a different aspect in the beginning. We missed the bus of registering the design of that. Second example, here, because of this incident, we became some wise. We developed another device, a very simple device. Probably it can be very important device in the healthcare field, particularly breast cancers. One of the one means 2-3 faculty members in our IIT, they developed a very small device which is of the size of this bottle, you can see, where just by simple breathing, the device will change its color. Like a pregnancy kit changes the color, so it will change the color, and by the changing pattern of the color, you can identify early stage cancer. And here, from very first day, we were also concerned about the design of the device also, that it should be a very appealing kind of a product, so that when it is on the table of the doctor, so it should look as a good product. And here, as soon as we filed the patent, we initially filed a design also. Now it is a different matter that now we have transferred that technology to a very large company which is doing more clinical trials, and they are suggesting that now we are trying to change the design also. So that is okay, because now we have a different partner in this process, and partner is coming with some different knowledge, and the partner feels that design need to be changed. But here I say that we thought to use this design option right from the beginning, so that when a person is breathing inside that device, it should have a aesthetically appealing device also. So generally in the healthcare, our patenting system is primary, while the design system becomes secondary. But many times when you need to use a device which is in the visible area, I think that you also need to focus right from the beginning on the design aspect also.
Thank you so much. Arupji, there are a couple of questions around design, I guess, issued. So the first question is from Shikanta, which is, what kind of proceedings can be carried out in case of design infringements?
Actually, in infringement proceedings all takes place in the court. not below the district court. And also these proceedings are that is beyond our office. So generally, one registered provider can initiate the process of the infringement any district court, not any court below, not below the district court.
Sure. And one other question from Kaustubh
But
is,
here I will like to add one point that the capacity of our courts to realize, because we do not have separate benches for IP related matters at the district court, and the priority, even the lawyers at the district level, they also not very much comfortable with the IP related matters. So that is a very challenging part, and we need to give a lot of efforts to improve our judiciary system if we want to become IP savvy nation, if we are into this race. So we need there is a term we used to say melt, where different type of disciplines, they need to come together, in which law is also very important. If legal system is not improved, the whole buck will stop without having proper legal remedies for IP infringements.
uh, sure, sir. Now, Arupji, Kaustubh is asking a question around image search. Like some other countries, IP offices have the facility of image search for trademark copyrights and designs. What is the plan of the IP office in India to enable image searches?
Actually, till now, there is no image search facility in the design in India. But we have already proposed this thing to, and also it is under consideration with the government of India. So maybe in near future we'll develop a tool where we can directly search the image. We can use the image search facility also.
Shah Saab, I can say that last year, when this National IP Day was celebrated at Delhi, uh, where in fact CG office was the main organizer of that program, our minister, Mr. Piyush Goyal, was there in the valedictory session as a chairperson of chief guest of that program, in which he actually gave a public statement that in Indian Patent Office, the design registration process will also be completely digitalized. And he gave an open challenge to all the IT companies sitting in that hall that I request any company to take it voluntary basis to make complete digitization of design process also. So I hope Aroopji can give some, you can say, idea that where is that process right now, and what is the timeline.
Sir, actually, now we are processing our design application in online mode. Means we are issuing the certificate through online also, and also we are yes to the registered provider, and also we are receiving the application through online mode. We are receiving the examination report through online also. We are giving hearing in online means through WebEx or telephonically, and also applicant have the option to file the hearing submission through online mode. So basically, the applicant can choose the total digital mode means online mode to file the design application as the existing module in our office. And the thing is that as per the concept of the image search, this facility is not available in our module. So generally, we generally carried out the search of the design as per the class basis or the title basis.
Okay, 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 okay.
Sure. So if you can pay attention to the chat box, if you have time permitting, everyone is just giving wonderful comments. There, everyone is very thankful of the insight that both of you are sharing. And it so rarely happens that in this age of webinar overload, people are asking for more deeper discussion. So everyone is genuinely appreciative of the knowledge and insights that we have been listening today. So thank you to both of you. And we are just at the dot of time. So I think it's a wonderful time to bring this session to an end. I'm sure our discussion can continue for far longer. Thank you, Anupji, for teaching us what designs are, how the registration processes work, going behind the scenes. Very informative. And Professor Agarwal, again, kudos to the work that you and the students and the faculty are doing at IIT Roorkee. Wishing you all the best. Thanks
Thank
again
you.
for sharing your insights with us.
Thank
And
you.
we look
Thank
forward
you.
to keep in touch with both of you.
Sure, sure, sure. We'll love to have more discussions.
Great.
Thank
And
you.
thank you on behalf of SHM IPR Council, on behalf of the L2 Pro India team. And again, much thanks to Kirti and her team, including Parul, for organizing. So thank you all.
Thank you very much. Thank you.
Thank you very much.
Thank you.
Thank you, sir.
Thanks. Great work.